Welcome to those of you who are signed in and on the Zoom meeting. This is the sixth lecture, national lecture in insurance law that we're proud to present. And today we have a particularly interesting topic from three diverse perspectives regarding auto insurance problems and policies and the various cross-border situations and legal issues presented by that. Let me launch right into it because we've got three fabulous speakers with extensive materials. Our first speaker is Professor Jeff Thomas from the University of Missouri, Kansas City, where he's a Brenner Faculty Scholar. He's extremely well known to an American audience as the editor-in-chief of New Appleman on Insurance Law, as well as a co-author of a 3-volume treatise on uninsured and underinsured motorist law. It is not excessive to describe Professor Thomas as perhaps the foremost expert in the United States on auto insurance law, and it's with great pleasure that I turn the program over to him right now.
Thank you, Jeff. I really appreciate the introduction, and I'm very honored to be part of this group and part of this lecture series. I've been a participant as an observer, and I really appreciate the quality of the work, and I really enjoy the cross-cultural perspective and dialogue. So I hope that I can add to that today. I'm going to share my screen and hope that that works so that you can see my slides. And I think that took it out of the mode that I wanted to be in, but those are my slides. Okay, so you see that? Everyone good with that? So really I want to give the US perspective. I have to apologize to my Canadian and Mexican colleagues. I understand that they're part of America too, North America at least, and but my expertise is in the American side of things, so that's where my presentation is focused. So I want to start actually with a few unique US perspectives that have a bearing on this. The first is federalism, which I suppose in some ways is not that different than the situation in the European Union, but there's a very robust state-to-state variation in law and very significant power that is maintained by the state separate from the federal government. And the federal government can step in, but in insurance, the federal government usually doesn't. There are some examples where they do. Certainly in auto insurance, the federal government is not involved. So state law predominates. And then the other big complication compared to other countries is that we're a common law country, which, you know, we say that as a buzzword, but what it means is that the courts are extremely powerful. And I just given three examples here. Insurance policy interpretation, extremely important in insurance matters. Those rules are all developed by the courts and they're all implemented by the courts. Bad faith is this whole regime of consumer protection that exists in the United States that has started basically in the 1930s, 1940s, and again is a very robust system of judicial precedent, not by virtue of, oops, sorry, I went too fast. Now I don't have my controls. Let's see. And then the third is that we have this public policy kind of argument that courts will embrace, where they'll say, we think because of public policy that these rules should be different. And so they can override policy language and in some instances maybe even override statutory language based on public policy. So there's this very robust judicial aspect to insurance regulation in the US. So my main thesis here is actually not very inspiring, I'm afraid. Choice of laws in the United States for automobile insurance is exceedingly complicated. A lot of that is because of the common law system and the federalism system. But at the end of the day, it doesn't really matter that much because it mostly applies at the margins. Most of the time, we're at the center of the disputes and there isn't a choice of law question. So let me give you the first complication, and that is that there are 5 different tests that are used in the United States. The traditional test, lex loci contractus, was started with the first restatement back in 1934. And that test is still used in a minority of states, about 11 or so states. And it says basically the place of contracting is the law that should apply. So that's the kind of traditional view, and that still exists. But the more modern view is the most significant relationship test. That comes from the second restatement in 1971. It's now the majority rule in most states. But of course, there are variations in what the most significant relationship test means. There are a number of different factors that you look at in order to apply the test. And so that, of course, complicates matters as well. The third test is the governmental interest test, and that is one that is another minority rule. It's sort of a variation on the most significant relationships test. Instead of looking at relationships, it focuses in a little bit more on what the governmental interest is. There are factors. What those factors are vary from state to state, but that's the way that you decide. The courts decide which law to apply. The Loeffler approach I really appreciate because it's an academic who came up with this idea. I call it the better law approach, as some others call it. He doesn't call it Professor Loeffler, who passed away, doesn't call it the better law approach. But it's similar to the government interest or the significant relationship test, except that it also takes into account which law is the better law. And so of course, that as an academic, I'm always saying, well, who knows which is the better law? It all depends on your perspective, doesn't it? Finally, there is one minority jurisdiction that follows the lex fori approach, which is the law of the forum presumptively applies unless there's some good, strong reason to not apply the law of the forum. So we have this whole spectrum of different kinds of tests. Complication 2 is that the elements are different and the elements are sometimes vague. So in lex loci contractus, of course, the question is, where is the contract made? And in insurance law and auto insurance and consumer affairs, that question is sometimes straightforward, but less and less so because of the internet. You have internet brokers, you have internet delivery, you have internet shopping, and we're not really sure where that takes place. It takes place in cyberspace. What jurisdiction is that? Is it where the servers are? Is it where the people are? It's a little hard to say. And that's just in terms of the modern internet aspect. Even in the old-fashioned system of mailing and so forth, the contract is signed by machine in one state. It's sent to another state. Is it the place of the signing? Is it the place of delivery? So there is some variation there. I mean, I think by and large, it's mostly where the insured resides as the place that the contract is made. The relationship test also has a difficult question, which is, where is the risk located? That's what the insurance version of the significant relationship test typically boils down to. But of course, with automobiles, which are mobile, it makes it a little more difficult. And then you have people who own multiple automobiles, or companies which own multiple automobiles or trucks in the commercial setting. And so there's some uncertainty about where the risk is located. And these vehicles move, and so they're in one state and then they're in another state. So there is just some uncertainty about that when you're applying that relationship test. In the government interest test, I think one of the main uncertainties is, how do you compare the interests? So one state has an interest in a law being applied a certain way. The other state has a different interest to be applied. They're apples and oranges. And so how do you decide which is more significant? That's, of course, a very difficult question. In the Loeffler approach, I want to focus on that idea of better law. As I referenced a moment ago, I'm not really sure what the better law is because it depends on your perspective. I have my own opinion about better law, but other people have their opinions too about what the better law approach is. And so there's significant uncertainty. And of course, depending on who the judge is and what the panel of judges look like in an appellate setting, they're going to have different perspectives on what the better law is. Finally, in the lex forti, the question here is, are there significant reasons not to apply the forum state's law? And what is significant, what counts, those things are matters of uncertainty. I've got a third level of complication here in the choice of law variation, and that's exceptions and variations. So the first significant exception is public policy. I mentioned that at the outset, that public policy is a very robust card that can be played by the courts. There is a public policy exception for the lex loci contractus, so that if the law of the contracting state should apply, if there's a good public policy, strong public policy reason not to, the courts can choose not to. And so that creates a pretty significant uncertainty. There's an exception for more significant interest to override the location of the risk in the case of the significant contacts approach, or the significant relationship test. So in those situations, it's like the public policy exception. To the extent that the court finds that there's an important interest that needs to be protected, that can override the fact that the risk is located in a particular state. And we're going to see both of these illustrated in a case in just a few minutes. Third, there's a variation for mobile risks that multiple states or other factors beside the location creates variations in how states approach the question of multiple risks. Some states will say, well, you look at one thing, some states will look at another thing. So there are ways to break those tides besides location, and that's a variation that happens from state to state. Then there's a variation on the Leffler test. Some states apply the Leffler test as he articulated it, is with 5 or 6 factors, including what is the better law. But other states simply add those on to other factors that come from the interest analysis, either the government interest analysis or from the significant interest analysis. So I've got a slide to try to illustrate this graphically. So in this slide, the big circles are the different rules. And the size of the circle reflects the number of states that adopt those rules. So lex loci, oops, sorry, I touched the pad and it moves on. Lex loci contractus is about 11 states. Leffler is about 5 to 10 states, depending on how you define it. Government interest is around those number of states. The most significant relationship is in the middle. The main takeaway point here is, first, the variety. Secondly, the substantial judicial discretion. When you have all of these factors and these variations, and the judges who have significant power in a common law system are applying those factors, then you have a lot of variation and substantial discretion for the courts. The little circles that say var and x, those are variations and those are exceptions. So you have the main rule and then you have exceptions to those rules. And I'm just trying to capture visually how complicated this is. It's just an illustration. It's my sort of interpretation, but I hope it illustrates the kinds of complications that we're facing in choice of law in the US. It's such a big topic that it's a topic unto itself, independent of auto insurance, of course. All that being said, I want to say why this is not a huge problem in the US, and that's because there's consensus around most of the major issues for auto insurance. So this is a list of those main issues. The insurance company has a duty to defend against potentially covered claims. That's true in pretty much all states. The insurance company has a duty to indemnify for bodily injury and property damage arising out of the auto accident up to the limits. That's true in all states. There's really not very much variation from state to state in terms of the auto exclusions. There's not a lot of litigation about the exclusions. There's some, I don't want to overstate it, but it's not a huge area of interest. Insurers' liability is subject to policy limits. That's pretty much understood, and that creates a great deal of problem in the US compared to other states because the policy limits are simply too low. And that's a historical accident. Those limits were put in place in the 1950s, 1960s. Most of them have not been changed, and most of them are very low. I think that you've heard in the past from Jeff and Eric that some states have 25, 50 limits. Some states have 15, 25 limits. What I often say is that those limits don't even pay for damage to the vehicle nowadays, and they certainly don't pay for any significant medical expenses. You just go to the hospital, stay overnight, and you've spent the $15,000. Finally, all the states do have a standard of good faith and fair dealing that is residing in the common law, that insurance companies have an obligation to act in good faith, and most significantly, that is an obligation to act in good faith with respect to settlement offers, which has morphed into the duty to accept reasonable settlement offers as it's articulated in the restatement of the law of liability insurance. So Even though there is broad consensus, I want to identify what I think are some of the main areas where choice of law issues are raised in auto insurance. The first is with respect to allocation or stacking. So there are many situations where two insurance policies will come to bear on a particular loss. The most common, I think, is a passenger and the driver, or the next most common is probably the driver and the owner, that those will each have their own policy, and so there will be a question about how you allocate and whether you can stack coverages within those. There are also other variations: employer, employee. The employee has his own policy, the employer has his own policy. The employee is out on business, but can his own policy come to bear to stack for one reason, to give additional limits? And there are situations where people are living together, and if they're related and living together but they have their own policies, they're covered under one another's policies because they're members of the same family in the same household. So those are a few areas where we have the allocation stacking issue come up. And then if you have those happen across state lines, you create a choice of law problem where the rule is one way on one state and the rule is another way in another state. So then you get into the choice of law about, is there a conflict and which jurisdiction's law applies. Second area of significance is nuances in bad faith law. So the general principle of bad faith is ubiquitous, but the variations of bad faith can sometimes lead to a choice of law question. The best example that came to my mind was there are a few jurisdictions where an insurance company has an affirmative duty to offer to settle a case. That's the minority rule. The majority rule is the insurance company has a duty to respond to offers that have been made, but not a duty to affirmatively make the offer. So that distinction could make a big difference in the outcome of a case. And if you have the right kind of facts, you might have a choice of law question between one jurisdiction that follows one rule and the other jurisdiction that follows the other. Perhaps the area where choice of law comes up most commonly is in the uninsured and underinsured motorist area. And I know that Jeff and Eric talked about this some in a prior lecture. This area is very robust and really quite complicated in America, and it's very statutory because the statutes require that these kinds of policies, these kinds of coverages be offered in auto policies. And that's not uniform from state to state, but most states require at least uninsured motorists be offered, and then most require that underinsured motorists be offered. So it's statutory, it's varied, and it comes up a lot because of the fact that so many people are underinsured in America. So uninsured or underinsured motorist issues arise. So I just put up four of the main issues. Well, the first actually is not the issue, but the context. Passengers are covered by the owner's policy of the car that they're in, plus they're covered by their own insurance. So that's a very common situation where you're going to have duplicative coverage. And then you will have this issue of, was the offer of coverage sufficient? That's a regulatory matter talking about whether the offer of uninsured motorists when the policy was sold was sufficient. If it's not sufficient, then by operation of law, you have the uninsured motorist coverage. So the way the uninsured motorist regime works is that insurance companies are required to offer it, but insureds can decline the offer. And then there are various ways of documenting that are allowed by the courts, and there's a regulatory overlay. So that's where that issue comes up, is was the offer proper? If it wasn't proper, then coverage is in place. The third issue, is the claimant legally entitled to recover? The standard for uninsured motorists is the insured, the claimant, is entitled to recover what they would have recovered if they were legally entitled to recover. And that then raises the question about certain affirmative defenses, right? So comparative fault, contributory negligence, whether it's a modified comparative fault jurisdiction, or whether it's a pure comparative fault jurisdiction, all those have bearing on the amount and whether, in some instances, there's coverage. So there are certain tort immunities and tort defenses that exist in one state that don't exist in another state that raise the question about whether the party would be legally entitled to cover. And then finally, as with allocation and stacking at the first instance that I talked about, Perhaps the most robust area of litigation is allocation and stacking of uninsured or underinsured motorist coverages. Many households in the United States have multiple cars. That creates a stacking issue. There's the owner and passenger situation I've referred to that creates multiple coverages. And so that creates the stacking problem. And stacking, there are like 50 different approaches to stacking in the United States. So which state you're in makes a big difference for purposes of stacking uninsured or underinsured motorist coverage. So let me give you a quick example. I'm almost out of time. This comes from Allstate versus Hague, which was a 1981 U.S. Supreme Court decision. There was a passenger who was on a motorcycle who was killed when hit by a car. The car and the motorcycle were both uninsured. The passenger had three other vehicles, which were each insured for $15,000. And so the question was, could he stack his uninsured motorist coverage to get $45,000 from those three vehicles, or was it $15,000? Wisconsin had a rule that said no stacking. Minnesota, neighboring state, had a rule that permitted stacking. $45,000 would be the coverage. So here's the relationship to the states. The dollar sign shows that Allstate sold insurance in both states. The contract was made in Wisconsin. The accident took place in Wisconsin. The driver of both vehicles, which are two of the houses, were residing in Wisconsin, and the victim was residing in Wisconsin. Sounds like a lot of contacts in Wisconsin. The only other contacts in Minnesota besides selling insurance there was that the wife of the passenger moved to Minnesota after the accident but before the lawsuit. So that's the house with the arrow. And then the decedent, the passenger, he actually worked in Minnesota and he commuted across state lines every day, and he'd done that for 15 years. But the accident didn't happen while he was commuting. It was on a pleasure outing, not on a commuting outing. So looking at this, it seems obvious, I think, that Wisconsin law would apply under almost any test, right? Wrong. The court found that the Minnesota court applied Minnesota law. They applied the Loeffler test and said that the better law was to allow stacking, because other states, that they said the majority allow stacking. I'm not sure that that was true at the time, but maybe it was. And they thought it was a better rule. And they found that there was a strong public policy interest in protecting this stacking idea, that it better allocated the risk. And therefore, even if we had the other tests, we would have had a stacking rule that would have been applied. So it shows how complicated this is and how it's a kind of topsy-turvy world. So here are my conclusions. Choice of law is complicated. We have the 5 different tests in the U.S. with uncertainties and variations. Courts have really broad discretion in applying these tests, which makes it very unpredictable. But most of the time, there's consensus on what the rules are for auto insurance, and so we don't have choice of law arising in very many cases. My guesstimate is maybe 1 out of 1,000 cases will have a choice of law issue. It's a little bit higher in uninsured and underinsured motorists. I review all those cases every year for the treatise, and I see one every couple of years that comes up. And so I'd say maybe it's 1 out of 500 there, but that's the area where it would be more common than auto insurance generally. And then finally, choice of law decisions are made at the margins, and the margins include things like allocation, bad faith, UM, and UIM. And when it is made at those margins, it's pretty unpredictable. So the last slide is just some references that will be available afterwards. Thank you for listening.
Well, thank you very much, Jeffrey. I suppose it's up to me to say thank you, because I'll introduce Helmut Heiss next. But first of all, again, Jeffrey, it was, as always, very interesting to listen to you. My observation was courts obviously do have broad discretion, but since that was on your last slide, I don't have to comment at all. You've said it all yourself. So let's move on, ladies and gentlemen, to Helmut Heiss. I know that introducing Helmut Heiss to this audience is a little bit like carrying coals to Newcastle. Everybody knows Helmut Heiss. Of course, he's one of the most prominent insurance lawyers in Europe. He has published extensively on insurance law, and he is famous for the pikel and the prickle, the principles of European insurance contract law and the principles of reinsurance contract law. He is a university professor at the University of Zurich, and at the same time, he is an attorney at law. And I know him for a very long time. I have known him for a very long time. And I'm looking forward to his presentation on international jurisdiction for direct claims. Helmut, I'll yield the floor to you.
Thank you, Christoph, very much. And I'm very happy, of course, to be here and to be able to present on this topic. It is a apparently narrow topic. I only deal with the direct claim that may be brought by the victim as against the liability insurer of the person liable. And I will deal only with the question of jurisdiction, because there have been recent developments in the case law of the Court of Justice of the European Union. And I think they were quite exciting. And so I would like to report on this development. The other question, what would be the law applicable governing the direct claim, can be answered rather easily, because we have a sort of what we call an alternative connection in this case. We will grant a direct claim to the victim if either the law governing the insurance contract or the law governing the tort or the liability will grant such a right. And in case of motor vehicle liability insurance, it's obvious that you are granted such a direct claim as a victim by the fact that the motor insurance liability directive makes clear that every member state has to introduce such a right of direct claim. So the existence of a substantive right of direct claim is not at dispute in those cases at all. When it comes to the jurisdictional issues, then the relevant source of law is the regulation of the EU number 1215 of 2012, which we call, for historical reasons, the Brussels IEBs regulation, and it deals with jurisdiction and the recognition and enforcement of judgments in civil and commercial matters. And I will only deal with the first part, namely jurisdiction. Now, the regulation, which is immediately applicable law in all member states of the European Union, rules on the jurisdiction in civil and commercial matters in general, but it has special chapters, special sections, and I would like to present the special section 3, which deals with the jurisdiction in matters relating to insurance. The term matters relating to insurance, which is different to insurance matters. It's a broad language that has been deliberately chosen to make clear it's not only contractual claims, but also direct claims of the insured party as against the liability insurer of the liable person. And I also displayed to you the relevant provisions in this regulation, which is first of all Article 13.2. It doesn't really tell a story. It only tells us that certain other articles, namely 10, 11, and 12, will be applicable where it comes to an insured party bringing a direct claim against a liability insurer. Doesn't have to be a motor vehicle liability insurer, but in many cases it will be. And it says where such direct actions are permitted. That's a question of the law applicable, but I've already mentioned due to the directives law in the European Union, it doesn't matter which law of a EU member state applies. In each and every member state, you have a right of direct actions. Now, the reference to Articles 10, 11, and 12 would force me to go to a very extensive discussion of direct claims. And in fact, the reference to 3 provisions offers a lot of options to our injured party, but I would like to deal only with one option because it's the most significant. It's the only one that is always used by all injured parties. It's the reference to Article 11, more specifically paragraph 1, litera B of the regulation, which says, and please mind the wording, that an insurer domiciled in a member state, some EU insurer, may be sued in another member state in the case of actions brought by the policyholder the insured or beneficiary in the courts for the place where the claimant is domiciled. Now you will have noticed that the injured party is neither a beneficiary nor an insured, and let alone a policyholder. So the question arose whether the reference in Article 13, paragraph 2 to the jurisdiction rule in Article 11, paragraph 1, literal B would make it analogously applicable, bringing in, so to speak, the insured party into this list of claimants in Article 11.1b, and granting the insured party its own home jurisdiction at the place where the victim, the insured party, is domiciled. The other way of interpreting this reference would be that the insured party may avail itself of the jurisdiction granted under 11.1b to the policyholder or insured. Since we deal with liability insurance, there will never be a beneficiary within the meaning of this provision. So if the insured, let's say the liable person, would be domiciled in Athens, then the courts in Athens would have international and local jurisdiction. That was the big issue, and it was very much debated up until the European Court of Justice decided the so-called Odenbreit case in 2007. It concerned a traffic accident in the Netherlands. The tortfeasor, the liable person, as well as the motor liability insurer were domiciled in the Netherlands. The applicable law, both in tort as well as for insurance, for the insurance contract, was Dutch law. The only connecting factor to Germany was that the injured party came from Germany, more precisely from Aachen, and that injured party had moved deliberately, without being asked to do so, to the Netherlands for some excursion and suffered injury in a traffic accident. And here the different opinions became decisive, and the court had to deliver a decision. The court decided that the reference in Article 11.2, that was the old provision of the former regulation, which is now the Article 13.2 that I have displayed, is to be interpreted as meaning that the injured party may bring an action directly against the insurer before the courts for the place in a member state where the injured party is domiciled. So 11.1b will be applied analogously to the injured party, and the injured party will have its own home domicile. That means in our case here, the injured party could sue in Aachen, Germany, and the court in Aachen had to decide this case. Now, I've never been entirely against the outcome of this case, but I have certainly thought that the dogmatic construction of it was wrong. I still think so. I will not go into it. I'll just point out that, first of all, it's not really helpful if in a choice of law situation, you end up in a system where quite in every international case where the injured party has left his home country and suffers damage in another country, the courts of at the hometown of this injured party will decide on foreign law, on foreign tort law, on foreign insurance law, with foreign witnesses that have to go to the forum and testify in foreign languages, usually with police documentation that will be in foreign language. That is systematically, in my view, not a good idea. But that's another story. And the second thing is that this decision deals with a motor vehicle liability insurance case, but the provision that it deals with is not restricted to motor vehicle liability insurance. So it may apply to any, large company that suffered damage somewhere and enjoys the right of direct action under, for instance, French law or Spanish law, and it will avail itself of a home jurisdiction, even if it's a multi-million euro company that could easily bring the action somewhere else. So those are my doubts as to this decision, but the baseline for everything I say from now on is the injured party enjoys home jurisdiction and will choose this home jurisdiction over all the other options that it is granted under the regulation. Now, certain follow-up questions came up. And one of the follow-up questions was, who is really the injured party? In an accident in Italy, meaning also that all the relevant connecting factors hint to Italy, there was an employee domiciled in Austria that got involved and got injured. This employee enjoyed by law the right to be paid under the employment contract, even though he was absent due to his accident. And so the employer has paid him money, and the employee has, to the extent that the employer has paid him, the employee has not suffered damage of loss of income. Rather, this damage was moved by law to the employer. And so it was the employer who tried to sue directly the insurer and brought an action at its own domicile in Austria, which was Klagenfurt. The city was Klagenfurt in Austria. And the question came up, could an employer who continued to pay the salary of its employee, and to which the employee's rights with regard to the company insuring the civil liability have passed, could it bring its action at its home jurisdiction? Now, the company, Kabek, said, yes, of course, we suffered damage due to the fact that we had to pay our employee. But the argument against it was that they were not the directly injured party. They only suffered an economic loss indirectly due to the payment obligations. Now, the court said that doesn't matter, since the original pecuniary loss, the loss of income, had sort of been transferred to the employer. And since the employer, by way of a legal assignment, a statutory assignment, I call it a subrogation, knowing very well that sometimes subrogation is not an assignment, not done by assignment, but functionally it's an equivalent. Those rights have moved to the employer, and now, to the extent that he has paid on the salary, the employer will be the injured party, being able to bring the action directly against the insurer and enjoying its own home jurisdiction. That means the court of the domicile of the employer will be decisive. In our case, it was Klagenfurt, Austria. In most situations, that will be basically the same place as if the employee would have brought the action. But of course, you have many employees that move across the borders every day. And so that would create a different jurisdiction. So we have also jurisdiction at the court of the place of domicile of the indirectly insured party, the employer. Now, sometime before this case that I have just described, the case in Vorarlberger Gebietskrankenkasse has been decided, and it was a very similar situation. There was an accident in Germany. The insured party came from Austria. The social health insurer, Vorarlberger Gebietskrankenkasse, was domiciled in Austria, and the social health insurer paid for health costs. And to the extent that it had paid for the health costs, under Austrian social security law, you have a legal assignment of the rights, a subrogation of the rights of the direct victim that would move on to the paying social health insurer. So basically, you could say that's the same case like the Kabek case. So the court should come out exactly the same way. The truth is the court came out exactly the opposite way. And it's not that the Kabek case that I have previously commented on would have overruled Gebietskrankenkasse. Quite the opposite. They both can be distinguished very easily. The point is, of course, Gebietskrankenkasse in this case is as much a insured party as has been Kabek, the employer. The difference between the employer and the Vorarlberger Gebietskrankenkasse is quite another. It's the fact that the Vorarlberger Gebietskrankenkasse is a professional in the insurance business, insurance sector, whereas the employer in Kabek was running a chain of hospitals, but was not a professional in the insurance business. And the Court of Justice has previously said in a reinsurance case that I cited here at the bottom line of my slide, that when it comes to two parties where none of the parties is weaker as compared to the other, which means they are both professionals in the insurance sector, doesn't make sense to apply Section 3 of Chapter 2 of the regulation, which intends to protect a weaker party. Now, as I said, Kabek was a company that was running a hospital. That may be a big company, and it may have a lot of money and sophisticated lawyers. Nevertheless, it is considered weaker than an insurer due to the fact that it is not professionally dealing with insurance. The opposite applies here. A social health insurer is considered by the European Court of Justice as a professional in the insurance sector. And so due to a lack of being a weaker party, to the fact that it's not considered a weaker party, the court decided that the whole Section 3 on jurisdiction in matters relating to insurance will not apply at all, and you will have to apply the general rules. So even all the other options under this Section 3 disappear. And when you apply the general rules, then basically the rule is actor sequitur forum rei. You have a forum of the defendant, and the Gebietskrankenkasse would have to sue the German liability insurer in Germany. There may be other special jurisdictions applicable, but none under the Section 3 of the regulation, and certainly not the home jurisdiction of the insured party. The reason was not that Vorarlberg Gebietskrankenkasse was not an insured party. The reason was that it was not a weaker party. Now, quite recently, about a year ago, the European Court of Justice had another case at hand. It was an accident in Poland. The insured party came from Poland. The motor liability insurer was from Denmark. And the plaintiff, CNP, was a Polish undertaking buying insurance claims professionally. So it obtained the insurance claim as against Gefion Insurance in Denmark by way of assignment, contractual assignment. So the chain of assignment was that the claim originated in the person of the victim. The victim had the car repaired in a repair shop in Poland and assigned the rights as against the liability insurer of the liable person to the repair shop, and the repair shop assigned the rights on to CNP, a professional buying insurance claims and then claiming the money from the insurers. The European Court of Justice said, even though CNP is not doing insurance business in a narrow sense, but since it is professionally buying insurance claims, it would be considered a professional in the insurance sector. And that means that even in such a situation, Chapter 2, Section 3 of the regulation, which contains all the protective rules on jurisdiction in matter relating to insurance, will not apply. Rather, the general rules will apply, most prominently Article 4, Paragraph 1, the act of sequitur forum rei rule, the forum of the defendant. What is probably more interesting than this showing up of another case of an insurance professional, which we probably would not have counted on before, is the fact that the court expresses its view that such a contractual assignment would in principle give the assignee, CNP, a situation where it would enjoy home jurisdiction under Article 13, Paragraph 2. The only reason why it didn't was because it was an insurance professional. Had it not been an insurance professional, like had the first assignee, the repair shop itself, brought the action against the insurer, then probably they would have said that's not an insurance professional, And so Article 13.2 will apply, and this repair shop will have home jurisdiction. Now, that really surprised me, I must say, for two reasons. The second one I've stated here, I would like to take that up first. The contractual assignee is never an insured party. He paid money to receive the claim, but it is not that by going on paying a salary, the damages suffered by the victim in the first place are economically transferred to an employer, and with this transfer of the damages, the claim comes along by a legal assignment. It's just buying claims. And I don't really see how somebody who buys a claim could be considered an insured party directly or indirectly. And when it comes to consumer jurisdiction, where you have the same phenomenon, the weaker party, the consumer, enjoys home jurisdiction. You have the famous cases of Maximilian Schrems against Facebook, where Schrems said, I'm a consumer. I've been assigned, I don't know how many claims by other consumers, and I will bring my own claim as well as probably hundreds of others in the court of Vienna, because this is where I have where I enjoy local and international jurisdiction, because it's my home jurisdiction, as I enjoyed in consumer matters. The European Court of Justice has said, no, even if you're a private person, even if you act as a consumer, if it's a contractual assignment, you do not create your own home jurisdiction in this case, and the consumer jurisdiction will not apply. So I wonder a bit why the European Court of Justice has, in principle, said that it would apply in the direct claim situation. Now, the fifth and last case I wanted to deal with is a gift of our UK friends, because it was very important that this point is clarified. It was referred to the European Court of Justice before the Brexit, and it was decided after Brexit. So thanks to our UK friends having referred this case to the European Court of Justice in time so that we have a decision today. It didn't deal with a traffic accident, but the way the case came out equally applies to traffic accidents. It was an accident in Spain. The liable person was a company domiciled in the Republic of Ireland, and the liability insurer was Spanish because this Irish company ran a hotel in Spain where a UK domiciled person was staying in and got injured during its stay. Now, what is the insured party doing? What do we expect it to do? Well, we expect it to bring a claim, a direct claim against the insurer in the UK. And this is what this insured party from the UK has done. There's no doubt that under Article 13, paragraph 2, there is jurisdiction, or there was jurisdiction as long as the UK was still a member state, home jurisdiction of the insured party for a direct claim as against the liability insurer. No doubt that far. However, the injured party sued at the same time and at the same court the liable person in the UK. And under the general rules on tort or even contractual liability, you may bring your claim for liability in various places, but not at your own home jurisdiction. The argument of the claimant, the plaintiff, was that Article 13.3 provided, and I've displayed here the wording of the provision to you, if the law governing such direct actions provides that the policyholder or the insured may be joined as a party to the action. That obviously was the case. It was possible to join the policyholder or the insured as a party to the action. Then the same court shall have jurisdiction over them. So the idea was, I bring jurisdiction to the UK by suing the liability insurer, and in a second step, by joining the policyholder or insured to the action, I avail myself of home jurisdiction also as against the liable person itself. And that's the most perfect situation if you can bring both the liability claim and the insurance claim at the same court, and it's home jurisdiction that is applied. Now, Fortunately, and very rightly, the European Court of Justice has denied such jurisdiction. And the most important and obvious reason is that the action brought against the liable person, even if it's combined with the action brought against the insurer, is still not a matter relating to insurance. It is simply an action in tort or contract if contractual liability is at stake. So Article 13.3 being part of Section 3 of Chapter 2, dealing only with matters relating to insurance, will not apply. It will be the general rules that apply. And then the European Court of Justice has found equally convincing other arguments why such jurisdiction would not exist. One is that the injured party is not a weaker party as compared to the liable person. Now, in the case at hand, of course, the liable person was a company running a hotel, they were running hotels, and the injured party was a natural person, apparently weaker than a rather big company. But that doesn't matter in matters relating to insurance. What matters is that both were not professionals in the insurance sector. And thirdly, and equally convincing, the former Chénat report that was, let's say, a statutory material combined with what was the Brussels Convention in 1968, which became later on the Brussels I and then the Brussels IAB's regulation, mentions that the insurer may join the policyholder insured, but doesn't mention the injured party having a right to join the policyholder insured under Article 13, paragraph 3. The real reason is that the insurer should be protected against fraudulent acts and should not face arguments once it had lost the direct claim action that it didn't properly defend itself and should have brought in the policyholder insured. Now, that's a totally different purpose of the rule. It's not the purpose to allow the injured party to bring the liability action also at the same jurisdiction also against the liable person. And finally, we have special rules on contractual claims, on tort claims in the regulation. And the court says you should not be able to circumvene those rules by connecting your claim with the direct claim brought against the insurer. Again, I think there was a lot of doubt. I've heard about many cases where this argument had been tried. And I'm quite happy that, as I mentioned before, that the UK have clarified that point. That brings me to the end of my presentation. I have not spoken about all the cases that have recently been delivered. There's several others. And again, there is one more very interesting case in the pipeline pending with the European Court of Justice. And we'll see whether we have something to discuss in the future on that. For the time being, I would just like to give you a reference to my own work on which this lecture was now based also, which is appearing in July of this year, which is the, I guess, well-known commentary of Magnus Mankowski on Brussels IABs within the European commentaries on private international law. And I had the pleasure to comment on Chapter 2, Section 3 there, the jurisdiction in matters relating to insurance. As it comes up soon, you can, of course, also read what I have said there. Again, thank you very much for your attention.
Thank you, Helmut. That was fascinating and remarkably applicable to all of us around the globe, no matter what jurisdiction you're in. We all have different ways to deal with some of these puzzles of direct actions. So really interesting to see those vignettes and how they played out. Thanks again. I'm pleased now to introduce Dr. Frits Blees, the former managing director of the Dutch Motor Insurers Bureau and Guarantee Fund. For the past 25 years, Dr. Blees holds a PhD in law from Erasmus University and is the co-author, as many of us know, of De Beer and Blees, Insurance Aspects of Cross-Border Road Traffic Accidents. Dr. Blees will be speaking to us today on motor vehicle third-party liability insurance and claims handling in a multinational environment. So the puzzles continue with Dr. Blees. Dr. Blees, we appreciate you being here. Thank you very much. The floor is yours.
Thank you very much. I'm afraid that my contribution to today's seminar is less lawyerly than the previous lectures. It's mostly I mostly approach the topic of cross-border traffic accidents and the claims handling in Europe from a practical point of view. And why is that? That is because the system, the main systems applicable are developed from a practical starting point. But first I would like to show what Europe is like. Is it, Oliver? I don't think the, yeah, no, it's the mouse, yeah. Europe is both a continent, but it's also, in a sense, a supranational entity. You see here the map of Europe. It's a colorful map, it's a colorful continent. You see blue, green, orange, and gray countries. And I hope to clarify in the next 25 minutes what these different colors mean from a perspective of cross-border traffic accidents. Europe, in a geographical sense, consists of some 50 states, some of them entirely situated in Europe, in the European continent, others extending well beyond the geographical borders. For example, Turkey, larger part of Turkey situated in Asia, and of course the Russian Federation, all the way to Vladivostok, is also a European country. 50 states, with all in all 750 million inhabitants, and all these inhabitants drive some 450 million vehicles. Now, with 50 states, that means 50 borders, and we're a rather international orientated sort of people, so there is a lot of cross-border traffic. Europe is also a supranational institution, the European Union, more technically the European Union plus the European Economic Area. It consists of the 27 members of the European Union plus Iceland, Norway, and the Principality of Liechtenstein. Still, those 30 states have some 450, 460 million inhabitants, and we own some 270 million vehicles, which also cross borders, of course. And all these states have, all these countries have a different history, they have a different cultural background, they have a different level of economic development, and they have all of them, whether they are blue or orange or green, they all have their compulsory MTPL insurance schemes, and they widely differ. Now, if we look at cross-border traffic accidents, we can distinguish in two different categories. And these two different categories have two different schemes of facilitating free movement of people and vehicles, and at the same time the protection of cross-border traffic accident victims. The first, and that's the oldest scheme, the first is the visiting vehicle is liable for the accident and the victim is a domestic in the country of the accident. Take an example in Spain, an accident in Spain injuring a Spanish citizen. and the author of the accident, the liable party, is a French vehicle. There we have, as a scheme to protect the victim, we have the green card system. Green, blue, and orange countries. Ignore the gray ones, they don't belong to the family of the green card. 47 countries in Europe, North Africa, and the Near East, covering all the way from Iceland. You can see in the left-hand corner, top corner, a little bit of Iceland. I couldn't possibly get it into the map in its entirety, and it goes all the way to, Alaska, almost. 47 countries, and the actors, and we will go into their function, are 46 green card bureau, I will explain later. Some 1,600 insurance companies are active in this entire area, and claims are handled by some 400 what we call nominated correspondents. I will come back to that later as well. Why 46 green card bureau instead of 47? It's 47 countries. That is because the Bureau of Switzerland is also responsible for claims handling with respect to the Principality of Liechtenstein. So that's the visiting vehicle is liable, and there is a domestic victim. And then there is a mirror situation. The victim is visiting another country, and the domestic vehicle is liable. Of course, there are also the possibility of a combination of the two systems, the two situations, of an accident in, let's say, France with a Spanish victim and a Dutch liable party, but that's a complication that we can easily ignore. So the victim is visiting another country, we call it the visiting victim. And for that situation, there is a more limited solution, and that's the 4th directive of the European Union, the Protection of Visitors Directive. That directive is only applicable in the blue countries, and not in the orange, not in the green. 27 member states of the EU plus the 3 member states of the EEA, Iceland, Liechtenstein, and Norway. Still some 1,250 insurance companies, more than 300 claims representatives, and we have the compensation bodies, which we'll try to explain later, and the guaranteed funds for uninsured and unidentified accidents. Let's go into the green card system first. Why? Simply because it's the oldest system. It was conceived in 1949, after the Second World War, when Europe emerged from the ruins of that great clash. The question was, with an increase of cross-border traffic and countries already having in place their liability insurance, compulsory liability insurance, how can one facilitate cross-border motor traffic without too many difficulties at the frontiers, whilst at the same time protecting the victim of a cross-border accident? And the answer was quite simple. Well, of course, it's always simple when it is in place and you read it afterwards, but it was very complicated to start with. The answer was, insurance policies shall be recognized. Domestic policies of the visiting motorist will be recognized as valid for accidents in the visited country, and what was necessary was an efficient structure for claims handling. Recognizing the insurance policy is quite all right, but how do you prove at the frontier that you are adequately insured? And the answer in 1949, 1953 became operational, was green card. And for our American participants, a green card in this case is not a work permit, it's an insurance certificate. There it is. I more or less modified my own green card this morning. Made it You can't just copy it and use it. But this is it. It is my own green card. You can see that I drive a Suzuki Grand Vitara 4-wheel drive. But it is a certificate issued by the bureau of the country of which the insurer is a member. It contains information about the policy holder, the vehicle, the countries for which the document is valid, and the date of inception and the date of expiry. Now, with an increase of motor traffic, it becomes a little bit difficult to check this green card each time a vehicle wants to cross a border. I still can remember from the 1960s the long lines waiting at the border for frontier officials, border officials to check for passports and for green cards. And that became increasingly difficult. And therefore, already in the late 1950s and the early 1960s, insurers were looking for better, more efficient alternatives. And they found the solution in the concept of normally based. When a vehicle is normally based in one of the participating countries, the blue countries on this map, and that can be proven by the registration plate or an insurance plate or an other distinguishing sign, then one can assume that the vehicle is insured. And of course, you can see from the outside of the vehicle whether it bears a registration plate or not of a given country. So that facilitated the cross-border traffic immensely. That was the aspect of facilitation of cross-border traffic. But now, structures for claims handling. What happens when a visiting motorist causes an accident in another country? And the answer was, in 1949, 1953, the establishment of bureau, green card bureau, associations of motor liability insurers in each and every of the participating countries. And those bureau have a double role. On the one hand, they guarantee the handling and settling of claims in the country of the accident. So an accident in, let's say, Germany provoked by a Dutch motorist, then the German bureau will be responsible for proper handling and settlement of the claim. And the bureau of the home country of the visiting motorist, in my example, the Dutch bureau, will guarantee the reimbursement of the handling bureau's outlays. So we have a handling bureau and a guaranteeing bureau. That's the theory. In practice, it works in a slightly different way, but this is still the basic principle. So the visiting vehicle is covered on the basis of either a green card or the concept of normally based, in practice, the registration plate. The bureau of the country of the accident is liable for handling and settling the claim, and the victim or the injured party has a direct right of action against the handling bureau. And that claim will be handled according to applicable law. I'm not going into that question, that's more for Helmut. It's usually the lex loci delicti or the lex demba. And the insurance policy will cover according to the requirements of the visited country. Again, an accident, and again, an example. In the Netherlands, there is a limited amount of cover for bodily injury, 6 million, and for property, 1.2 million. Limited, well, I'm quite sure that our American friends will think that's not a proper term, but compared to, for example, Belgium already, or France, or the UK, it's limited because there is, for bodily injury in those countries, an unlimited amount of cover. So when a Dutch vehicle would cause an accident in Belgium or France, the Dutch policy will cover unlimited. And according to the other legal requirements with respect to insurance. Once the claim has been settled, reimbursement is guaranteed by the Bureau. In my example of a Dutchman causing a Dutch vehicle causing an accident in France, by the Dutch Bureau, either on the green card, but in the blue, in between the blue countries, it is the registration plate. Now, back to the green card. Green cards can be falsified or illegally altered. Already in 1953, the Bureau agreed that also illegally altered or false green cards would be guaranteed. So at the frontier, it was not a question to verify whether the green card was genuine or not. Simply, if it looks like a green card, it is a green card. And registration plates can also be falsified or stolen and applied to another vehicle. That was also simply guaranteed. That has changed by the fifth directive, but in principle, the registration plate is sufficient proof that the vehicle is insured, which means that also uninsured vehicles are guaranteed by the Bureau system. Now, how does claims handling work in practice? Well, as I said, the Bureau of the country of the accident is liable, but only in exceptional cases, the claim is handled and settled by the Bureau itself. They are simply not capable of handling all these claims, so they are outsourced. Insurers, the members of the Bureau, may appoint representatives in the countries where they provide cover, and we call these representatives in the green card system nominated correspondents, and they usually are either insurance companies or branch offices or subsidiaries of the insurance company, but in most cases they will be commercial, internationally active claims handling organizations. They handle and settle the claims in the name of the Bureau, but on behalf of the insurance undertaking. That means they act as both as a representative of the Bureau and of the insurance company at the expense of the insurance company. Important is that the insurer is not allowed to instruct neither the Bureau nor the correspondent on how to handle and settle the claim. And that is logic, because the applicable law is the law of the most, in the large majority of the cases, is the law of the country of the accident, where the nominated correspondent is active and where the victim is domiciled. And a foreign insurer is simply not capable of interpreting the law and the rules on how to settle a claim. A French insurer cannot possibly, well, that's perhaps a little bit too strong, but you can't expect a French insurance company to interpret Turkish law if an accident happens in Turkey. That's the expertise of the nominated correspondent. Direct right of action of the victim against the Bureau, also, although in the large majority of the cases, the correspondent is entrusted with the handling of the court proceedings on behalf of the Bureau, but still it's the party and the defendant in court proceedings are the Bureau. Once the claim has been paid, and it is important to emphasize that the victim must be compensated before the correspondent or the Bureau can demand reimbursement from the insurance company or the bureau in the country where the vehicle is originating from. Then the bureau, the handling bureau or the correspondent is entitled to reimbursement of the compensations paid, plus external costs for experts, for medical expertise, for the court case, plus a handling fee of 15% of the previous amount, with a certain minimum and maximum. It's all based on standard agreements between the bureau and the insurance companies comply with it. Reimbursement has to be paid within 2 months, and there is a rather strong incentive to comply with this period of 2 months, because ever since the beginning of the green card system in 1953, there is a penalty of 12% late payment interest. Now, if that under the current bank rates isn't an incentive, then I don't know. It's if the bureau, the correspondent that handled the claim doesn't receive the reimbursement, then the handling bureau can call in the guarantee of the debtor bureau, and then that also is the proverbial big stick to comply with the rules. So what we have 47 countries in Europe, North Africa, and the Near East. We have cover on the basis of a green card or on the basis of the normally based principle. The cover complies with the requirements in the visited country, and there is a central role for the Bureau, a very strong role for the Bureau, which ensures that insurers, the 1,600 insurers, comply with the agreements and the rules of the game. Actual claims handling is done by nominated correspondents and no influence of the insurer. Now, the hope of the green card system, 47 countries, in 2019, some 460,000 claims were handled and settled on the basis of these rules. In 2020, it was 33% less, simply because the COVID travel restrictions reduced the number of reduced international travel, but still some 450, under normal circumstances, some 450,000 claims are handled and settled annually. Now, the mirror system is the fourth MID. The victim is here a visitor and not a local party, and the author of the accident usually is a domestic motorist in the country of the accident. Now, that has a narrower scope, for not the 47 countries of the green card system, but simply the 30 countries of the European Economic Area and the EU. And there is no central role for a national entity such as the Green Card Bureau that controls what happens. The role of the compensation body on the first side looks a little bit like that of the Green Card Bureau, but it cannot be compared. We'll come back to that later. As I said, more limited scope for, in fact, 4 reasons. The visitor must be a citizen of an EEA member state, one of the 30. The accident must take place in a member state, but it cannot be the member state of domicile of the victim. And the liable vehicle must not be normally based in the victim's member state of domicile, nor insured. And why is that? Because in all these 3 cases, the victim can directly apply an entity, the insurance company, in his own country. There is no need for extra protection under the 4th Motor Insurance Directive. So it is already rather complicated. If you thought that the green card system was complicated, brace yourself, because the 4th MRD is far more complicated than that. EEA insurers, that is insurers established, domiciled in the blue countries, must appoint claims representatives. In the green card system, they are allowed to do. They are allowed to nominate correspondents under the 4th directive. They are obliged to nominate representatives. And they must be domiciled in the country where they are active. They must be capable of handling and settling claims in the language or languages of the country where they are active. Take, for example, Belgium. They speak Flemish, Dutch, and French. So a claims representative must be able to speak both languages, and they must be fully authorized to handle and settle the claims entirely, including payment of the victim. All insurers, but that also goes for the claims representative, must provide within 3 months an offer of compensation, if that is possible, because the liability is not disputed and the damages, it's clear what the damages are. And if not, they must provide a reasoned reply on all elements of the claim if there is contesting, if the liability is not clear and the damage is not quantified. What happens, and it happens, when the claims representative or the insurer do not comply with the 3 months obligation to provide an offer? Then the victim, the injured party, has access to a central entity, the compensation body. In most countries, it's either the bureau or the guarantee fund, not a separate entity, but we call it the compensation body. And that compensation body first invites the insurer to come with an offer or a reasoned reply within 2 months. And if there is still no offer after those 2 months, and I remind you, we're already talking 5 months after the accident, if there is still no offer, then the compensation body takes over the claims handling. If there is a reply within those 2 months, then the file goes back to the claims representative or the insurer. There are also situations where there is no claims representative, for example, because the insurer failed to nominate one, or the vehicle is uninsured. Of course, there is no claims representative, or the vehicle is unidentified. In that case, the victim can immediately go to the compensation body, and that will start to handle and settle the claim itself. Reimbursement structures are also rather complicated. There are no rules about reimbursement between the claims representative and the insurer that appointed him. It's based on private agreements, and there is no guarantee such as the bureau provided under the green card system. But if the compensation body of the member state of domicile of the victim has compensated the victim, then it has a right of reimbursement from the body, its counterpart in the member state where the insurance undertaking is situated, and that is in the case of the 3 and 2 months situation, or if no claims representative has been appointed. If the vehicle is uninsured or unidentified, it will be a claim on the guarantee fund of either the country where the vehicle is normally based, if it's uninsured, or of the country of accident if the vehicle is not identified. So, in summary, 4th MRD compared to the green card system, it is rather complicated. I still have difficulty in trying in summarizing it within, 25 minutes, half an hour. There is no central role for the compensation bodies, which there is in the green card system. There are no uniform rules of procedure for the claims representative, and there are complex reimbursement structures. So, some conclusions. First, accidents caused by visiting motorists, the green card system covers practically all of Europe with a few exceptions. You see some countries here east of the Black Sea. But it covers the almost entirety of Europe. It has a proven efficacy of almost 70 years. Next year we will the 70 years will be celebrated, and we have very few complaints from victims and injured parties. The number of court cases from victims and injured parties against the Bureau is, in my view, in my experience, very limited, and that also goes for the reimbursement question. The number of court cases, there are, as far as I know, no court cases between Bureau about reimbursement, recourse, and the number of arbitration cases between Bureau are also very, very, very limited. So it works. Accidents with visiting victims, more limited geographical scope, more complex to handle, less central steering, stronger position of the insurers compared to the green card system, and more or less as a consequence, there are fewer statistical data about the quantity and the quality of claims handling and settlement. Yet, very recently, the 6th directive was published, and it was, in my view, a little bit surprising that there are no new proposals or no new rules concerning the protection of visitors, which am I going too far if I say that according to the European Union, the 4th directive structures work well enough? Let's hope so, in the interest of the victims. Thank you very much. This was my part, my contribution to today's seminar.
Well, thank you very much, Dr. Blees. That was very interesting. You took some really complex rules and boiled them down. And also, we now know what you drive. I know we have 2 questions in the chat. With the couple of moments we have left, I wonder if I might turn them and see if we can just briefly address them with our speakers. And I'll start with the latest one first from Peter Fisher. And I think that's to you, Dr. Blees. Peter asks, what about when there's an accident of 2 parties from different countries and the claim occurrence is in a 3rd country? What happens then?
In fact, that's a very interesting question. In fact, that is, let's make an example. And let's concentrate on the European Union, because it gets more complicated if we take a country like Moldova or Turkey, because that's outside the European Union. What you have then is a combination of the 2 systems. You have both the green card, the visiting victim, the visiting motorist causes an accident, but at the same time you have a 4th directive case, and the victim has the choice to either apply under the rules of the green card, but then he has to go to the green card bureau of the country of the accident, or he can apply the rules of the 4th directive and go to the claims representative of the insurer in his own country. One of the dangers we saw when the 4th directive was introduced in 2002, when it became applicable in 2002, was that I mean, insurers are always a little bit, well, careful about fraud and that sort of thing, that victims would misuse, make abuse of the 2 systems and file their claims with both entities, both with the insurer, the claims representative, or in case of uninsured vehicle, with the guarantee fund, and with the green card system. So the victim can use both systems. He can choose, but the bureau and the guarantee funds exchange information in order to prevent double payment of compensation. I hope that's a beginning of an answer to the question.
No, that's great. Thank you. And an interesting wrinkle nonetheless. Thanks, Peter, for the question, and thanks, Dr. Blees, for the response. And if we can sneak this one in there, the first question was from John Buchanan at Covington. who I think it's going to Jeff Stemple, who noted, John noted, Jeff, that you're on the conflicts third restatement members consultative group, and he wondered if there's been any discussion of choice of law rules applicable to auto insurance. Anything there?
Let me respond before my mea culpa that for those who aren't familiar with the American Law Institute structure, they're the reporters who do the heavy lifting on drafting. There's a set of designated advisors. Professor Thomas and I were, and Mr. Buchanan were all involved with the liability insurance restatement that way. Members consultative group, one can volunteer for, and therefore you get on the mailing list, so to speak. And there's a tendency when you're on that outer tier to free ride, which I have, which means I'm not prepared to give a considered answer to the current status of any discussion of insurance. I am now motivated to do that, and will certainly reply to John and to our group. And if anybody in the audience is interested, just shoot me an email. It comes up immediately if you Google me at UNLV, and it's a reminder that I need to do that and have not been following it closely.
No worries. Great. Well, thanks, John, for the question. And thanks to all of our speakers today for a wonderful event. We appreciate you very much. And thanks to our audience as well. A brief reminder before we close that our next event is coming up at the end of September, September 29th at 3 o'clock UTC. Our topic is going to be insurance in times of war. So very timely topic. It's going to cover a number of range of issues, and we hope you'll join us at that time. Thanks to everybody for joining us today, and be well. We appreciate you here. Take care.